So, question number 8 asks what is meant by ratification, what are its essentials, mention the rules as to ratification. So, the very definition of ratification is provided under section 196. So, as per the meaning and definition of ratification as provided under section 196, ratification is the adoption by X of the benefit and liabilities of a contract made by Y on his behalf, but without his authority. Although a man may be without any actual authority to do an act on behalf of another, the subsequent adoption of the act by that other has all the effects of ratification of previous authorization, where acts are done by one person on behalf of another, but without his knowledge or authority. He may elect to ratify or to disown such acts. If he ratifies them, the same effects will follow as if they had been performed by his previous authority. So, this is how the very definition of ratification is provided under section 196. And under section 198, we'll discuss the essentials of valid ratification. So, regarding that, we'll discuss the very essentials of valid ratification. Number one is that the act must have been done for and in the name of the supposed principal. And the second essential is that there must be full knowledge to the ratifier of what these acts were. And the number three essential is that the ratifier should be competent to authorize the act ratified. And the fourth essential of valid ratification is that the principal for whom the acts was done must be in existence at the time of doing that act to be ratified. And the fifth essential of a valid ratification is that there must be lawful act to be ratified. Thus, a forged signature cannot be ratified. And the sixth essential is that ratification must be of the whole transaction. And the seventh essential of a valid ratification is that the act must be ratified within a reasonable time. And what is reasonable time is a question of fact. And the eighth essentials of a valid ratification is that no valid ratification can be made by any person whose knowledge of the facts of the case is materially defected. So, all these 8 essentials of valid ratifications are provided under section 198 of the Indian Contract Act 1872. So now we'll discuss the very principles involved in ratification. So the very principle on which ratification is based is of sound commonness and public policy. Otherwise, persons would not be safe and secure in acting on the unauthorized demand of third persons or strangers for the supposed principle. It avoids the trading activities from being minimized. So, the very principle governs ratification, and as regarding that also in relation to the very liability regarding the principle, and now we'll discuss the effects of ratification, and all these effects of ratification is that the same consequences will follow as if the acts ratified were done with the authority of the principal. And secondly, ratification takes effect from the date of the act done and not from the date of ratification as by the agent. So now we'll discuss certain rules governing to ratification, and such rules are provided under section 199 and 200 of Indian Contract Act 1872, and in relation to the rules as to ratification, we'll discuss an illustration. So the very rules as to ratification, it may be express or implied. For instance, A without authority buys goods for B. Afterwards, B sells them to C on his own account. So here B's conduct implies a ratification on the purchase made for him by A. And secondly, the very rule is that a person ratifying any unauthorized act done on his behalf ratifies the whole of the transaction of which such act formed a part. And the third rule governing ratification is that ratification of an unauthorized act cannot injure third person by subjection him to damage or of terminating any of his right or interest, as such rules provided under section 199 and 200 of the Indian Contract Act. And the very illustration relating to the rules is that A not being authorized, that by B demands on behalf of B the delivery of a chattel, the property of B, from C, who is in possession of it. This demand cannot be ratified by B so as to make C liable for damages on his refusal to deliver. And in our upcoming video, we will discuss question number 9, which relates to What are the consequences of notice given to an agent?